Hello, everyone, and welcome, and thank you so much for joining us today. We are absolutely delighted to have you join us for this distinguished lecture on international economic law and the right to health. I will now hand this over to Ms. Ranjani Ray, Assistant Professor at the Center for Trade and Investment Law, Indian Institute for Foreign Trade. Thank you.
Welcome, everybody, and sorry for the delay. I look forward to getting started as quickly as possible. It gives me great pleasure to have the last session of this delightful symposium that discussed so many interdisciplinary issues related to health. And I am grateful right now to introduce our distinguished lecturer, Professor Lauren Bartels. Professor Bartels is a professor of international law and a fellow of Trinity Hall at the University of Cambridge. And he's an expert on issues related to international economic laws, and he teaches international law, WTO law, and EU law at the University of Cambridge. He's also a general editor of the Cambridge International Trade and Economic Law series and an editorial board member of several journals. He's also helped establish the Society of International Economic Law. We also have with us Dr. Anup Vadhavan, who is going to be doing our welcome address, and it's a great pleasure to introduce him. He is a distinguished professional with extensive policy experience. He has served as India's Commerce Secretary, showing expertise in foreign trade and investment, as well as roles in banking, insurance, capital markets, and others. Dr. Vadhavan also has provincial policy-making experience in regions like Uttar Pradesh and Uttarakhand. His career also includes district-level development administration, public administration roles, highlighting his diverse skills both in rural and urban development. Dr. Vadhavan has also spent time at the World Bank and African Development Bank. I will also be introducing Professor Dava, who will be doing our concluding remarks. She's an associate professor of economics at JGLS, and she approaches her subject matter from an interdisciplinary perspective and integrates law, politics, philosophy, sociology, psychology with economics. So we look forward to everybody's view. And just to introduce the topic, I think I'll take 2 minutes of everybody's time. Since disease has been an unfortunate traveling companion of international trade and commerce in time immemorial, although the right to health is more than just avoiding disease, we've learned throughout the course of this symposium that the right to health is enshrined in international economic law, international law, specifically international human rights law. However, where does right to health lie in international economic law? And how does international economic law impact the right to health? These are some of the questions that we hope to get answered in this discussion. And I look forward to introducing Dr. Vadhavan for his introductory and welcome remarks.
Well, thank you so much for the very kind introduction. Needless to say, I'm delighted to be here to be part of this very, very important session on international economic law and the right to health by a very distinguished guest, Dr. Bartels. My sincere thanks to Dr. Bartels, to the organizers, and all the very distinguished participants for making this experience possible for all of us. To briefly set the tone, let me say that along with other welfare-oriented social interventions in areas like education, nutrition, hygiene and sanitation, housing, public transport, etc., creating affordable and convenient access to quality healthcare, both preventive and curative, is a key determinant of ensuring the minimum set of outcomes that constitute a humane society and promote growth with equity. I think the re-emergence in recent times of huge socio-economic inequalities is today a major threat to the capitalist model of development and is a reminder of the consequences of ignoring these critical areas of basic human needs that public policy needs to emphasize. In developing countries in particular, health shocks have long been recognized as major factors preventing sustained emergence from poverty through measures targeting employment and income growth. As the background note to this conference itself states, addressing these concerns are not a medical matter alone, but a matter which is moot to the very stability of the social fabric itself. Achieving these widely recognized health outcomes involves policy choices, having opportunity costs and trade-offs amongst conflicting stakeholder interests inherent to the highly contested political economy of most nation states. We have to make conscious policy choices in this context. Questions like, should the basic healthcare approach involve direct public provisioning through agencies like, for instance, the NHS in the UK, or is Singapore's nationalized universal health insurance model combining targeted subsidies and individual contributions the way forward, or whether a model based entirely on private service delivery and insurance provisioning with state mandated inclusivity provisions at the margin is the way to go, which we perhaps see in countries like the US, or is a prudent combination of these the best way forward? These are some of the choices policymakers must make at the cost of other priorities, and to that extent, a choice has to be exercised. These choices also involve issues of striking the right balance between providing essential social safety nets while not undermining incentives to work and persevere for innovation and productivity growth. If you see the approach of the US and the EU, that balance is struck very, very differently, balance or imbalance as you might call it, and it's a choice between some basic public policy principles, some basic public policy concerns, and the incentives to work and the incentive to innovate. And of course, this entire picture, which I've mentioned at the national level, is complicated by the fact that we live in a globalized world. And in this globalized, interdependent world, achieving these national outcomes involves, in addition, the difficult interaction of these contrasting cross-country national political economy imperatives. So the political economy of nations differ, and these interactions shape the international environment in which the sort of enablement of these national goals will happen. It requires difficult inter-country cooperation in shaping the international health-related legal framework comprising IPR regimes and trade laws to deliver socially desirable health outcomes across the globe. The objective of affordable global pharmaceutical access, for instance, is one such area involving appropriate IPR regimes at a national and global level that balance reward for drug discovery with public health goals and affordability of drugs. These global framework conditions and the flexibilities they afford nation states involve disciplines within the WTO, GATT, GATS, TRIPS, the entire TBT and SPS provisions, and also policies of other international bodies like the WHO, FAO, and the standard setting bodies. So they constitute the entire framework within which the international environment for achieving public health goals globally and public health goals at a national level will be shaped. The key question is whether current arrangements strike the right balance for achieving the minimal desired outcomes across the world, while the reality of very unsatisfactory access to essential medicines across the globe, combined with huge private sector profits, would indicate that the balance attempted has been struck disproportionately in favor of private profits. There are still persistent demands and pressures from business interests and governments for evergreening of patents through measures like data exclusivity, patent term protection, etc., with the disingenuous logic that somehow these things are good for everyone. I think as people from a legal background, I don't need to elaborate too much on this issue. And the recent experience of trying to make COVID vaccines and other medical supplies accessible through globally agreed IPR relaxations reveals how inadequate currently available flexibilities and country attitudes are in addressing requirements brought up by even such a rare one-time catastrophic occurrence like the COVID epidemic. So even in those very, very difficult times, the world could not really come together to find a solution, leave alone doing it in, more normal times. So, is publicly funded R&D coordinated by national governments the way forward, or is there some case for a global consortia of like-minded governments that promote research and development, have the IPRs which can be then used for public purpose while balancing, the cost, etc., of innovation? These are some of the questions to which the global community at large has to find the answers to. And luckily, I don't have to answer them myself. And I take the liberty of leaving this difficult task to our very, very distinguished speaker of the day, Dr. Bartels. I welcome him here to this institute and to India. And I now invite him to make his remarks. Dr. Bartels.
Well, Dr. Wadwa, thank you very much. Those were fantastic opening remarks, and I hope to build on them. Thanks, everybody, for being here, first of all. Also, thank you especially to Professor Nedumpara, who is responsible, I think, for me being here in the first place, and many others as well. But let me get to the point. What I'm going to talk about is, in fact, does it say it there? Yes, it does. International Economic Law and the Right to Health. A simple title. I prefer simple titles because I find even simple titles are complicated enough without challenging myself by making them even more complicated. And what I want to talk about is the complicated relationship between the international economic law regime and the human right to health. And when I say international economic law, what I'm referring to is mainly trade and investment, although I might also say a few things about intellectual property law, that being the primary theme of this conference. So let me start by reminding myself really, about what the right to health actually is. The first time this was properly codified was in the 1946 Constitution of the World Health Organization, which said that health is a fundamental right. The enjoyment of the highest attainable standard of health is one of the fundamental rights of every human being. And this basic right to health has been restated many, many times since then. States have an obligation to protect, respect, fulfill the right to health for all without discrimination. So the obligation to fulfill, enjoy, respect the right to health is binding on all states. It's also customary international law. So how does international economic law, in the sense of trade and investment agreements, relate to the right to health? Well, the main purpose of these agreements is tangentially related to health. In fact, it's an objective of these agreements. The core of these agreements, if you look at what they actually do, might seem distant from the right to health, but if you look at their objectives, it's fairly closely related. The general idea is to facilitate the free movement of goods, services, and capital across borders, and to create a stable and predictable environment for international commerce. Now, why do I connect this with the right to health? Because the whole point of doing this is to make people richer, to make countries richer. And it does. Trade and investment does make countries richer, including India, including China. Poverty has gone down around the world. I'm not an economist, but I do read The Economist, and I believe in its charts, and that to me seems to be undeniable. And when countries are richer, there is more money. People have more money, and countries have more money to spend on health, among other things. But overall, countries are richer, and overall, people are richer. But that doesn't mean, of course, that everyone does well when it comes to economic liberalisation. What does economic liberalisation do? It's a tool that reallocates economic resources. And this can be good for some, obviously it has to be good for some, otherwise there wouldn't be an increase in wealth. It can be good for those particularly who are involved in new export industries. They are winners. But of course there are also losers. And those who are going to lose, and this is not an accident, this is the very purpose of trade liberalisation, is to make people lose. No two ways about it. They will lose their jobs. Those who are in domestic industries now suffering from import competition. Now, there are answers to this problem of what to do with the losers from globalisation, although what seems to happen in reality, rather than as a matter of government policy in just about every country, is just to wait for the next generation who maybe will not be in those losing sectors and ideally will be in newer and winning sectors. But of course, it can take more than a generation for all of this to come good. Now, this has implications for a state's human rights obligations, because if people become poorer, we focus on the losers now as opposed to the aggregate, where everybody on aggregate does better off, then the state will have an increased burden in ensuring that their rights are respected, including the right to health. Now, another aspect of economic liberalisation is privatisation. Now, privatisation is not mandated by any international economic agreement. They are neutral when it comes to this, but it tends to be the theme, and countries do tend to privatise when they engage in economic liberalisation. And this can also be a good thing when it comes to the right to health. I don't need really here to do much more than to point to Jindal's motto, a private university providing public service. You can say the same thing about private organisations, private entities providing services, healthcare services, or other services that are connected with the right to health. And one can also say that competition, if properly regulated, is desirable because it forces the state sector to lift its game. But of course, that's the upside. There are also downsides. The UN Special Rapporteur on the Right to Health, Paul Hunt, has pointed to the risk of creating a two-tier healthcare system, if we limit ourselves now to healthcare, one for the rich and one which then somehow seems to become increasingly underfunded for the poor. And there's another problem, which is that if not properly regulated, privatised services that are essential for public health, like the provision of water and sanitation, can be worse than government-provided services, which are more easily controlled. And that's important, for instance, when it comes to universal service obligations. So there are upsides to economic liberalisation, both at the macro and at the more micro level, but there are also significant downsides. And that might cause some to point the finger at the international agreements which promote economic liberalisation. And so my question now is whether this is fair, or whether these agreements promote economic liberalisation, but they don't actually mandate those sorts of activities or government policies which can lead to these negative outcomes, and whether those happen to be economically associated outcomes with those agreements, but they're not necessary. That's really the question. Economic liberalisation is not the same thing as economic liberalisation agreements. So in answering this question, I would like to run through something essential about these agreements, talk a little bit about how they work. And here I would draw a very sharp distinction between investment agreements and trade agreements. Investment agreements are based on an investor's property rights. And sometimes this right can be a monopoly right. Now, an obvious example of this is intellectual property, which is a property right, and it's also a monopoly right. And one doesn't have to be a competition lawyer to know that that is risky. The main question when it comes to that sort of exclusive property right, monopoly right, is whether, if you're having to pay money to exercise that right or use aspects of that right, whether the price is right. And essentially, if you have a monopolist, that monopolist is going to be setting the prices. This is an obvious problem, and much of yesterday was talking about what you can do when the price for intellectual property, in the context of essential medicines or COVID vaccines, is too high. It's not only intellectual property which has this characteristic of being an exclusive property right, a monopoly property right. You can also get this with other types of investment. For instance, utility providers. Utility providers who provide services like water, for instance, often also exercise a monopoly, a geographic monopoly in that particular case. There's only one company in your area that will provide water services. And again, the question can be, well, is the price for these services right? It's an economic problem. Now, the legal problem is that in international underinvestment agreements, the right of these monopolists is protected. And the question then is whether the protection of those property rights includes a protection as to the value of those property rights. And this is obviously going to be very much contested, and it's one of the big issues in investment law. And not only that question about whether the value can always be protected, but when it is, and the answer to that question is yes, how one calculates that value. Does one calculate the value of a property right in terms of sunk costs or market value? Or if you are talking about market value, whether that market value should somehow include lost profits. These are all economic but also legal questions. There is a case in which this was at issue, and I'm going to refer to this a little bit later on as well, Urbaza and Argentina, where Argentina revoked a concession to provide water services from the company, the investor. In part, there were various reasons, but one of the reasons was that the concessionaire was selling water services at too high a price. It was a monopolist, and the prices were simply too high. One of the other problems was that the quality of the water was also going down, and there were a few other things, including Argentina's financial crisis. This is all very different in trade law, and that is for two reasons. So firstly, in trade law, there is no concept of an individual right. There is no such thing as a right to trade. Also, I should say, there is no such thing as a right to trade in any national legal system, at least none that I have encountered. If anybody knows of one, I'd be pleased to know about it. What is protected under trade law are the rights of states to trade, WTO members, parties to free trade agreements. This means that no individual trader is protected. It is the totality of trade in a particular product or service from a particular state that is protected. Now, of course, if there's only one trader at issue, then it makes no difference. In substance, you might as well be talking about the rights of that trader. But even if that's true in substance, the difference becomes important again at the procedural level, because the state doesn't always want to protect its traders, not even an individual trader, and the individual trader has no access to the system. There is no compulsory diplomatic protection anywhere really, but certainly not in trade law. And even if the state does decide to protect the trader or the group of traders in its or from its country, then other states can refuse to comply with their obligations, and if they do that, what happens? They have the option of compensating the affected state by offering market access in other areas, no use to the poor, harmed trader, or doing nothing at all and suffering retaliation which harms their traders, but again is of no use to the harmed trader. And I can say from a practical perspective as a practicing trade lawyer that trying to explain to companies how little they are protected as entities by the international trade regime is not good for business. The second difference is the type of protection under trade law. investment rights are protected in two ways. One is on an absolute basis, and that's what I was talking about before. They are also protected on a relative basis via the principle of non-discrimination. Trade rights don't have any absolute protection. They are purely relative. The governing rule in trade law is non-discrimination, and that means that one state can mistreat all products, for instance, or service supplies of a given class, so long as it mistreats all of them equally. Then you don't have discrimination. So trade law is inherently more flexible for governments than investment law. And not only this, non-discrimination in trade law has been interpreted in WTO law in a way that protects the right to health. And the reason for this is that products, and it would be pretty much the same with services and service suppliers, I imagine, products that cause harm are typically not the same as products that don't cause harm when we are speaking about health. And the obvious case to refer to here is EC asbestos, where the appellate body said that asbestos was not comparable to an asbestos substitute for the simple reason that asbestos kills you and the asbestos substitute does not kill you. And if you don't have any comparators, if you're not comparing apples and apples, but apples and oranges, then you don't have the beginnings of a discrimination complaint. It doesn't always work though. For instance, in Chile alcohol, Chile claimed that there was a differential tax on alcoholic beverages according to how much alcohol was in them. And one of Chile's arguments was that it needed to tax high alcohol drinks more than low alcohol drinks because this was important for the right to health, as part of its health program to discourage people from drinking high alcohol drinks, or at least drinks with more alcohol than the local beverage Pisco, which has about 25% alcohol, which is why Chile lost the case. But what's interesting about this is that Chile didn't bother to make this argument at the stage of the obligation. It didn't say high alcohol drinks and low alcohol drinks are apples and apples. Sorry, apples and oranges. It accepted that they were essentially apples and apples. Chile made the argument in the context of an exception. I'm going to say something about exceptions in a moment. And why is that important? Because if you have a government policy that doesn't draw a binary distinction between the good products and the bad products, like banning asbestos and allowing non-asbestos, and those products are different, but rather the government policy is graduated according to how much a product is dangerous. So how much alcohol is in a drink, how much tar is in a cigarette. And there's more of a restriction, more of a tax, more of a burden of some kind, more of a license fee on your car according to how much greenhouse gas it emits. And if you have a graduated policy like that, it's very hard to draw the line anywhere on that, well, line on your chart and say, this product here is not like this product just a little bit above it. Consumers will treat the products as effectively the same. And yet that's how many government policies work, and for good reasons, because when it comes to trade exceptions, that's precisely what you need to do, is to calibrate your measure to the risk of harm which you're trying to address. But at the stage of the obligations, when it comes to discrimination, and again, that is the fundamental, one way or another, obligation in all of trade law, it presents you with a problem because you are much more likely to have discrimination. So there are problems with international economic law, both investment law and trade law, although to a lesser degree, when it comes to the right to health. But when I say problems with the law at the moment, all I'm talking about are the obligations, and those obligations are to be distinguished from exceptions to those obligations. But I want to focus on the obligations because obligations in any regime tell you what that regime is about. And the exceptions tell you when you think there is another value that is more important than the regime that you are actually talking about. And I want to make this point because I'd like to declare myself to be against a reimagining of international economic law in a bold and strong way by including in trade agreements or in investment agreements obligations about human rights. I think that's a mistake. I'll give you an example of one of these obligations. A counterclaim obligation, which one sees in newer investment agreements, and one sees it also, for that matter, in the 2015 India model BIT. What is this obligation? To give you the Indian example, India is able to counterclaim. So when a company claims against India, India can counterclaim against that company. If that company has failed to comply with Indian law, including, and now I'm quoting, the law relating to human rights. So why do I think this is a bad idea? It sounds like a great idea. It sounds like we are finally rebalancing a regime that is asymmetrically in favor of investors. Well, I'm against it because I think the investment regime is about protecting investors. That doesn't mean that I think that investors shouldn't have to comply with local law, or maybe not even that they shouldn't have to comply with human rights law. But I don't think that those issues need to be in an international investment agreement. They can be in other regimes, which, by the way, and most importantly, and I'm going to explain how this can come about, can live outside of the investment regime and can have priority over the investment regime. I think it is better to keep those apples and those oranges separate. There are two other reasons why, practically speaking, a counterclaims model is problematic. The first is, well, if India really cared about whether a company is complying with local law, including human rights law, shouldn't it just sue the company? Should it really wait for that company to sue India and then countersue against the company? It seems difficult. Also, it can be self-defeating for the state to do this. In Urbaza, Argentina counterclaimed against the company, saying that the company had failed to comply with human rights. And most people focus on what this means for companies' human rights obligations as opposed to states' human rights obligations. But one of the other interesting aspects of Urbaza, which I think should make states pause before going for counterclaims, is that the tribunal said that Argentina was really responsible for complying with the right to health. And it even hinted that if the concessionaire had not done the right thing, call it a violation of an international health obligation or something else, that was going to be bad news for Argentina's own obligations. In other words, if India counterclaims against the company, what's it doing but declaring very close to a violation of its own obligations under international human rights law? I can't imagine, other than Argentina, and maybe because of Argentina, states litigators putting the state in that position. So what is the solution? Well, exceptions. And I think this is really very simple. Exceptions tell you a couple of things. Most importantly, they tell you that you think there is something that is more important than the regime which is enshrined in your obligations. Exceptions are not trivial. Exceptions are hierarchical. They say, we love the regime up to this point and no further. They are fundamental to any regime and they are very powerful. There are three types of exceptions that I will offer to you. Maybe there are different ways of slicing these, but I'll suggest three. One is a definition. Again, the India BIT has a good example of this, and this I like, as opposed to the counterclaims provision. A legality clause, investment lawyers here will know what I'm talking about. The legality clause in the India BIT says that an investor, for the purposes of the BIT, is an enterprise that is operated in compliance with the law of the home state. In other words, a foreign investor that hasn't complied with India's law, including, of course, India's human rights law, has no rights under the investment treaty. It's an exception for human rights violations, including the fundamental right to health, as well as any other violations of Indian law, for that matter. A second type of exception is not via a definition, but via a non-application rule or a carve-out, and this is a separate rule which expressly excludes the application of an obligation to a given fact. Another example from India's BIT. This treaty shall not apply to the issuance of compulsory licenses granted in relation to intellectual property rights. It's a non-application clause. The rule normally applies to facts, but not these facts. There are other examples. For instance, some treaties, CPTPP, USMCA, a few others, have carve-outs from ISDS, Investor-State Dispute Settlement, for tobacco control measures. Agreements on trade in services typically do the same thing in a variety of ways for trade in healthcare services. The agreements simply don't apply to that economic sector. A third type of exception is what you might consider to be a true exception, like the general exception in GATT, Article 20 of GATT. And this is expressed in the form of a right to engage in certain conduct, usually for a particular policy reason, even if doing this conflicts with an obligation not to engage in this conduct. And the way that this works is that you essentially have a right to do X, you have an obligation to do Y, and you have a hierarchy rule that says X prevails over Y. So, Article 20 of GATT is a classic example, but also the TRIPS waiver is the same thing. Notwithstanding the rule that says we can't do this, we are allowed to do this. Now, there are some differences between these techniques. The most important difference, I think, is to do with burden of proof. And there are a few other refinements which treaty drafters will know very well in terms of how you calibrate the means to the end when there's a policy exception and so on. But their function is the same. It is that a given international economic law obligation does not apply in certain cases. So, one might ask, would it be a good idea to make the role of human rights even more prominent in this context? Could an exceptions clause say, notwithstanding this agreement, the parties may take measures directed at, or necessary to, if you're conservative, complying with or promoting, if you're less conservative, their human rights obligations? There are clauses like that in the field of international environmental, or rather, international environmental law as mediated through trade agreements. There are clauses that say nothing prevents the parties from complying with their agreements, their obligations under the Paris Agreement, for instance. Is it a good idea to introduce an exceptions clause like this for the human right to health or other human rights? Maybe for other human rights, I would say, but probably unnecessary for the right to health, at least where you already have exceptions clauses, because those exceptions clauses already allow for measures that are necessary to protect human health, and that, after all, is the whole point of the obligation to ensure respect for, well, and more, full enjoyment of the right to health. So I don't think it makes a great deal of difference with this particular human right, provided that you have the right exception there. And of course, there is no overall exception like that in TRIPS, for example, nor in every BIT. And I would say I am a supporter of including general exceptions clauses just to make sure that you have access to those more important values than the international economic values which are enshrined in those agreements. So, where does this leave us? First, I think it is undeniable that for all of its benefits, and I don't minimize those for a moment, economic liberalization can have negative effects on the right to health, both at a macro level and at a more micro level for individuals. Sometimes this can be linked to obligations in particular agreements. Sometimes it's just government policy, and I would draw a distinction between the two. Again, there is no obligation to privatize. So those problems are actually government policy problems. But if you do privatize, the obligations kick in. It's important to draw those distinctions because governments sometimes point to international agreements as excuses for what they're doing when it's actually just their choice or their choice not to do something. These obligations, though, are often subject to exceptions. Those exceptions are there to permit states to act to discharge their obligations for higher values, including human rights values, and among those including the value of the human right to health. So the relevant question to my mind is not about transforming these systems by including new human rights obligations, somehow integrating them into the human rights world. I would say keep the apples and the oranges separate, but make sure that the oranges, which are the human rights regime, prevail over the apples. And the best way to make them prevail over the apples is to make sure that you have proper effective exceptions clauses which make it very clear where your hierarchy lies. Now, there is work to be done to make sure that there are those exceptions in international economic agreements, and of course there will be debate as to how far those exceptions should go. But as an overall structural objective, I would say that is all that is needed. It is a modest proposal, but a workable one, and I think both from a policy perspective and doctrinally, it is the best way to make sure that human rights, including the right to health, are properly respected in international economic law. Thank you.
Thank you so much, Professor Bartels and Dr. Vadhavan, for your introductory remarks and for your lecture on how economic law and right to health interact. I will invite Dr. Dava for her concluding remarks and look forward to the conclusion of a great symposium.
Thank you, Professor Bartels. It was a very insightful and a very thought-provoking lecture. I'm still wrapping my head around it because I'm not a lawyer. So what I am planning to do is, out of various hats that I have, put my political economist hat and analyze the lecture based on that. A lot of points may be scattered a bit because too much information. First thing which I want to talk about is the idea of economic liberalization and the conversation around that it is not imposed on countries. I am not sure if that is true, that if something is not necessarily has to be imposed for it to be complied upon. When countries take IMF loan package, they are given an austerity package, whereby privatization becomes a part of that package. So there is a compliance which has to happen, and something that was the case with India as well in 1991. So, so something which, yes, liberalization, I will get into the positive and the negatives of it, but the point that privatization may not be imposed, but can be still complied upon, something. Then I want to talk about that you say that economic liberalization is going to lead to some losers, and that is what it's made for. Sure, Of course, there will be winners and losers, but that is the entire point. That are we going to then just let everything there will be a free pass because there is going to be inequities and losses, and then wait for next generations instead of having economic laws which can already account for those losers in their international operation. So that's another point. And then there is a point which you talk about investment, IPR, as well as the trade law differences. My point, and I borrow here from Professor Shantl's lecture yesterday, and that is the rising transaction costs because of these disputes, which keep on happening because of the IPRs, and we are not letting the information, and something which you are, I think, talking to. You're saying that there is an increasing in disputes, and then, I mean, your investment, sorry, the IPR, the patents and the knowledge transfer, the technology transfer, the access to medication, all this gets stuck in the disputes, and there is a rising transaction costs for the companies as well as states in case of especially the BITs. Then you talk about the solution of imposing exceptions and limitations, and let apples be apples and oranges be oranges. I am not so sure if first the first question, at least, that comes to my mind is that would, and something which you pointed out, that there will be have to be a careful drafting of it, but the complexity of the drafting and then implementation of that drafting in itself can lead to further complications and rising disputes instead of going towards that route. At least that's the way I see it, and this is, of course, based on just quick thoughts, that there is a case in point to integrate health as a fundamental human right in the economic law itself, because you are ultimately, when you're talking about liberalization, trading, you're opening up the nations, you are creating labor codes, at least in case of India, where the labor, the working class is suffering so much that their health is suffering, and what the obligation is of the state, and state has signed that trade agreement whereby they are supposed to reduce have wage repression due to the austerity package. They are supposed to have de-unionize, not promote unionization. So in that case, where is the protection measures if health is seen as isolated human rights subject from the economic law? It will have to have an integration there because economics is having an impact there. So also coming to the point of one more thing that I want to talk about is something which Mr. Dr. Vadhavan talked about, and very rightly so, about public spending. And ultimately, the one lesson that the pandemic has taught us about the public health is that there is need for public infrastructure, healthcare, public healthcare, and we cannot wait for another pandemic to invest in public healthcare. And private healthcare can only build up on the public system. Unless the public system is not strong, you are basically then trying to have a private profit-driven model of healthcare, which is going to serve a particular class of customers. And yes, you are then creating customers. They are not patients anymore. So I think that, and that public spending government spending again has to figure out if there is an austerity package, there's an economic law which asks you to have low public spending, and rather than having the Keynesian crowding in, then you basically are reducing your public spending. Then what are you like? There is going to be no research, no knowledge transfer, no. I mean, you can have it in the agreement, but then all that you will be seeking will be a knowledge from the Western nations or the nations who are doing better off than you, instead of building your own capacities. And tragically, one thing that India, just a stat for everyone, that India spends only 2.1% as of today in the health, 2.1% of GDP. Out of all the BRICS nations, we spend the least. And the idea is that there is an international law, there is an economic law, there is human right, and health is a fundamental human right. But you have to integrate these, according to me. You have to think of more constructive solutions whereby the public funding is more important. It has been taken into account, and then only private sector can build. Privatization may not be mandatory, but we are all compelled to do it. And what that ends up doing is it ends up creating further inequities, further losers, whom we are not catering to because there is no public infrastructure. So thank you. I always keep the time.
Thank you so much, Dr. Davar. I do think we've had interesting amalgamation of perspectives from a policy perspective, an international economic law perspective, and a socio-economic perspective. And I don't know if we have the time for a Q&A, but we actually have a special but short speech by Dr. Abhay Shukla, who wants to talk about something very contemporary, and we look forward to hearing him out.
Big thanks to the organizers for giving me this opportunity to have the last word in the last session. It'll be very short, and it's something about very practical and ongoing and perhaps also urgent, and which directly relates to the theme of our entire symposium, which is about the interplay of health law, society, and political economy. And although this doesn't deal with international law, it's probably parallel to the whole issue of, how our existing laws deal with the right to health in this country. So, as a public health professional and a public health advocate, not an advocate like most of you, but somebody who does advocacy, I'd like to share with you this legal development which is very recent and which has taken place in the Supreme Court. Some of you may have read about it in the newspaper, but it has come very briefly. It has not come actually in the level of detail which it deserves. So there are two public interest litigations going on right now in the Supreme Court. Both deal with the core issue is regulation of rates in private hospitals across India. And recently, and both these PILs were filed in 2020-21 during the COVID pandemic, when, as you know, what was happening in private hospitals was obviously quite obvious that the rates in private hospitals were really prohibitive. In many cases, there was a lot of profiteering. So one of the PILs is by the Veterans Forum, which is a forum of retired army officials. Many of them are retired army doctors. And the other is by Jan Swasthya Abhiyan, with which I am associated, which is a nationwide platform of health professionals and health activists. So on 27th of February this year, in the Veterans Forum case, the Supreme Court gave an order that the central government, in keeping with the Clinical Establishments Act rules 2012, must standardize rates in private hospitals across the country, at least in those states, 12 states which have adopted the CA, which is a huge and significant order. And it also said that if the central government faces some delay in standardizing the rates, then the CGHS rates should be applied in all private hospitals. Now this is something, I'm not right now going into the details because that's a matter of some discussion, but as a principle, saying that now the act was passed in 2010, the rules were passed in 2012, now we're in 2024. So now it's high time that the rates are standardized. This is a very significant order. And in our case, which was heard on 5th of March, just about 15 days back, the Supreme Court reiterated the need for not only standardization of rates, but also transparency of rates, which is also there in the CA rules 2012. And both now these cases have been tagged with each other for hearing, and the next hearing will be there in mid-April. So now this is, in my opinion, a very significant, and now for your information, the Private Hospitals Owners Association has filed, not too surprisingly, has filed a counter intervention seeking to intervene in this case, and they have completely and flatly challenged the mandate of the government to regulate rates. It's not just going to some technicality that which rate should be there or how should they be. They have said you do not have a right to regulate rates, and they have also said to the Supreme Court in language, if I put it in simple language, Supreme Court should stay out of this matter. That is essentially what they have said in a little flowery language, that the Supreme Court should reconsider, and this is not the role of the Supreme Court. And basically the stakeholders in the health sector, which means the private healthcare industry, should be left to do what it feels is appropriate. So here there are three very important legal issues which have come up. And now this case is going to open up a big panorama of debate, in my opinion, and which is going to be, it will be healthy even if we do not quote unquote win the case, but if the issue gets placed on the agenda, then it's going to be something significant, because number one, the principle of regulation of rates of an essential life-saving service. Does the government have a mandate or not? Of course, there is a CA, but even broader than that. So for drugs, we have a drug price control order under which all drugs, or at least a large proportion of drugs, are supposed to be regulated. During COVID, 15 states across India regulated the rates for COVID care, at least for COVID hospitalization care. For electricity and certain other sectors, we do have standardized rates. So for an essential service, can the government regulate rates or not, even if it is being given by private providers, is one important principle. The second is the legal instrument being used for regulation, and this is the weaker part of the argument, is CA and CA rules 2012. So whether this is legally robust enough or not is also needs some little more investigation, and also we need to look at other parallels in India. Where else have rates been regulated or standardized, So standardization does not mean that they should be economically unviable, obviously. I mean, the hospitals have to continue, they have to be sustainable, but so making profit is okay, but super profiteering is not okay. I think that is essentially the main point that we are trying to make. And the third and the main plea which has been given earlier by the Union Health Ministry and is also being referred to by the private hospitals is that the central government cannot do this, let us leave it to the state governments. And once that is said, that opens up, and that's what essentially the plea is being made, that it's a state subject, so let the states decide it. And now if you ask these 12 states, Mizoram or Himachal or whatever, that now you sit and work out a framework for regulation of hospitalization rates, which is like thousands of procedures, it doesn't happen. That was done almost 2 years back, 2 or 3 years back. The states were asked to do that, and none of them have done it. So it's obviously the states are not doing it, and it's unlikely that on their own they will be able to do it. So this is another, but it's linked to the whole federalism kind of framework, federal framework that we have. So some appropriate, so it needs to be central government in consultation with the state governments. That is what the Supreme Court has said, that you do it in consultation with the state government, but you have to now accelerate the process, or you have to. And the fourth is, of course, from a health point of view, a healthcare point of view, the technical aspect, that there's a lot of variation in input costs. So if you have a small private clinic in a remote rural area, there obviously the costs of land, the costs of human power are going to be somewhat less. If you have a large clinic in South Delhi or Mumbai or whatever, the costs are going to be higher. So they cannot be blanket rates. There needs to be a differential. There needs to be a reasonable differential. So all these factors can be addressed. So in my understanding, it is a complex issue. It is a challenging issue. It's not straightforward. but it's not impossible. So if we want to make the what is challenging but possible, but not impossible, if you want to make it possible, it will require some more thinking and some more efforts. So of course we are already working with our lawyers, and just yesterday and today I've met some of our Supreme Court lawyers. But I can tell you that this requires a little more effort and a little more help. So my appeal is that we are putting together a kind of an expert team now to help our lawyers in building some more, arguments for the case. So any of you, it's going to be a multidisciplinary team. So we already have an alliance of doctors for ethical healthcare. So we're calling upon doctors who run their own hospitals, who have a good ground level sense, so they won't go in for something unrealistic, who know how a hospital runs, who know how hospital rates get shaped, to be part of this team. But we also need some legal experts. So I'll appeal to you that if any of you are interested, younger professionals or whatever senior professionals, if you would like to be, at least we can have one or two, online calls to discuss it, to brainstorm about it, give us some new ideas. So please give your names to Professor Deepika or to Anmol, and we can take you as part of that process. We'll be very happy to have your inputs. And secondly, as citizens, because you're not just lawyers or legal experts, we will be launching a social media campaign very soon, and we would like you to sort of take up this issue, propagate it. The point is that a space has been opened up to talk about regulation of private healthcare in this country. It was actually overdue. It should have happened immediately after COVID or during COVID. So during COVID it happened to a certain extent, and then again it got pushed into the background. So now that space has opened up again in the country, in this country today. Apparently it is the Supreme Court which is one of the spaces where these kind of issues at least still can be taken up. So I think that it was great to be part of this symposium over the last 2 days, and it is said that the proper fruit of knowledge is action. Or as another old German philosopher said, that the philosophers have interpreted the world in various ways, but the point, however, is to change it. So I'm just appealing to you to take this point on board, and if possible, please contribute to it. Thank you.
Thank you so much for that perspective. I'm sure students and participants will definitely consider this. And now that we're at the concluding aspect of this symposium, I'd like to invite Dr. Professor James J. Nedumpara, Head of the Center for Trade and Investment Law and Chair of the India Chair of WTO Chairs Program, for his concluding remarks. Unfortunately, we didn't have any time for questions since we're already running quite late. I hope we can take any questions bilaterally. Questions? Is there any deep questions that we're waiting to be answered? Otherwise, we can go on with the concluding remarks. I think we can go ahead.
Thank you, Ranjini. Dr. Anu Vadhavan, former Commerce Secretary, Government of India, Professor Lauren Bartle, Professor Ashida Dawa, and the distinguished participants from various countries, from India, the faculty at General Law School, OP General University, my colleagues from CTIL. So at the very outset, let me actually thank one person who is actually responsible for why we are here, and that is Dr. Anu Vadhavan. So let me tell you, in 2017, I was actually teaching at General Law School. I was teaching international investment law and economic law. And the idea of starting a new center was actually conceived during his time, while he was the additional secretary of the Department of Commerce. And he was actually the head of the panel that recruited me as well. So thank you, sir, for coming here and being part of this particular program. And I can tell you that our center has been doing quite a bit of remarkable work in the last 6 years, 6.5 years, going into 7th year. And Professor Rajkumar actually, he gave me 1 year leave to start the center and come back to General. Now it has gone on to 7th year actually. Right. So thank you to Professor Rajkumar as well, because I think he is a visionary. As I mentioned yesterday in my initial presentation as well, Professor Rajkumar has got a great vision of starting a world-class university in India. And many people like me, because they joined this place in 2009, And when we see the fruits of the labor, of course I left after 8 years, not fully but partially, this has actually come to become one of the best places of legal education, not only legal education in the country, but in terms of interdisciplinary studies in the country. And full kudos to Professor Rajkumar, his team, the faculty, the student who kept the flag flying. Now General has actually got into the top ranking, in the QS ranking, it is actually ranked 72. And I should also tell you that because of the vision people had about our center and the role these kind of agencies can actually play in state capacity building, we are not only providing help to the government of India in some of the ongoing negotiations, we are also helping a number of other countries as well. So, and we are trying to create a narrative in the field of international economic law, trade law, investment law, and a number of free trade agreements for that matter. So we believe that what we have done so far is good, and these kind of conferences will have a major role to play in the years to come, because what we have done is only a small amount of work. It is actually the tip of the iceberg. We have to really start working, consolidating the knowledge that we have, to have establishment, tie-ups with the various institutions, have people like Chantal Thomas and Lauren Bartle come and talk about these kind of issues, and ultimately we have to publish as well. So I think we are having a grand vision at the moment, and this is only one among the many activities we have done in the recent times in order to fulfill this vision. So my role for today's conference is basically to provide a report, and I can tell you there was an overkill of information. We ended at 9:30 yesterday, and started at 9:30 and ended at 9:30, and then we started off at 7:30. So it has been a huge amount of information overkill, mental fatigue, physical fatigue, but I can tell you we covered a large number of issues. So Professor Lauren Bartle spoke about a very really innovative, interesting arguments. I had a lot of questions in my mind, and Devika told me that there is no question Q&A in a keynote. But the fact is that you touched upon a number of issues: how to keep the oranges oranges and how to get the apples. These are some of the perennial issues which are actually confronting the space of international economic law, not only international economic law, but when we think about the recent sustainability debates in particular, the PPM debate and everything. So these issues are extremely important, I think very significant in terms of the future of international economic law. But we did not only look at the linkages between the international economic relations. A bulk of the presentations that happened today and yesterday in this conference actually touched upon domestic topics relating to issues like abortion, for that matter. So I was actually taking a look at the topics covered in the program. We had a number of very interesting issues. I don't want to go through all of them. I was privileged to sit in some of these discussions, and the kind and quality of inquiry and deliberation that happened and the questions that followed in the program were just amazing. And I hope that the participants, the people who presented the paper, will be able to complete their paper in time, so that we are proposing to come out with a special edition of Gender Global Review on some of these issues, and we will come out in a very short period of time. So the papers at the moment, I have gone through some of the papers, but not all of them. Some of them are in a fairly advanced stage. A lot of work is actually required in other papers. But we had to also understand the fact that this was a very, very hurriedly organized program. We thought about it in October and came out with the call for paper in December, and they had only 2 months' time in order to submit the paper. And then organization happened in the last 1 month. So there was very limited amount of time in order to organize these kind of activities. But in this conference also, I will just like to talk about some of the very important points that came on the plenary sessions. The first plenary session was very active and very vibrant. It was actually chaired by Dr. V.K. Paul, who played a very important role in the COVID fight in India. Right? He was responsible for developing the vaccine, making sure that people get timely vaccination. And he spoke about the importance of access to medicine, right to health, and shared his experience of policy setting in India and during the post-COVID-19 pandemic. He emphasized on the need for inspiring leadership in policy making, particularly health policy. This was followed by 2 prominent plenary sessions. The first plenary gave interesting points for thought and discussed interlinkages between health, trade, and access to medicines, particularly with the aim to address how countries can attempt to balance between economic and public rights and the correlation with the labor rights and sustainability. The second plenary session was particularly interesting. It actually deviated a bit from health and provided some kind of inputs to the young scholars, the people who are starting their career, how to publish and get visibility for their work as well. And it also touched upon a number of important issues like funding issues, the focus of research, diversity in policy formulation, and also the need to have work grounded in empirical evidence that can address the diverse needs of the population. Then there was actually a session with respect to Kerala. Kerala has been at the forefront in terms of providing healthcare, and the role of local institutions, districts, panchayats, municipal bodies in ensuring access to health was actually touched upon. In the second session, I think there was a discussion on health governance, the role of intellectual property rights, access to medicine, research ethics, and the role of technology in shaping health outcomes. Then, of course, we had a masterful keynote address by Professor Chandel Thomas. She spoke about the need for high political engagement in these issues and how countries like India should actually play a key role in the political discourse in international economic law. And then last, we had the great talk by Dr. Anu Vadhavan and also by Professor Lauren Bartle. So I think we had a very rich, enriching 2 days of discussion of the meeting. I would like to thank everyone for contributing to this program. Thank you.
Thank you so much, Dr. Nalampura, and to Dr. Vadwan and Professor Bartels, Professor Ashita, and Ms. Ranjani. May I now request Ridish and Disha to please felicitate our guests. Thank you so much, Ridish and Disha. I now invite Disha Chaudhary, Clinical Assistant Professor and Assistant Director, Center for Justice, Law and Society at Jindal Global Law School, and Pranav Narang, Associate, Center for Trade and Investment Law, IIFT, to deliver the vote of thanks, please.
Thank you so much, Firoza, and everyone who's still stayed with us till the end of the day. I think Professor James has done a fabulous job of walking us through how intensive the last 2 days have been, so it's only right that we thank everyone that has made this possible now. I'm going to share this vote of thanks with my colleague from CTIL, Pranav, but before I do, just a little bit about what brought us here, the ideas behind organizing this symposium. So the politics of knowledge production is something that we as scholars and researchers continue to confront on a daily basis, and it is avenues and spaces like this that allow us opportunities to both engage, interact, and also understand the responsibilities we carry in producing knowledge. We are very grateful to all scholars, activists, and community leaders, especially Dalit and Adivasi scholars, queer feminist researchers, and all of those who've provided us the vocabulary to think through intersectionality, marginalization, and what it really means when we speak of realization of rights through the law. We've had 2 very exciting, intensive days of engagement with wonderful sets of people. And it's been many months in the making, so it only is prudent for me to acknowledge the efforts of everyone that has supported as well as made this endeavor possible. On behalf of the Center for Justice, Law and Society and the Center for Trade and Investment Law, I want to begin by thanking some of the people whose names have not made it to the agenda, as you've all read. So I want to begin first by acknowledging Mr. Mithilesh Sham, the artist, whose artwork has been plastered on many, many standees, posters, agendas, and we've had the privilege of using this as a platform to showcase their art and share it with all of you. On behalf of us at CJLS and CTIL, I want to extend a huge thanks to the logistics team at JGU. I want to start with the transport team and Ravinder ji, the food and events team, specifically Rosemary ma'am, Vikas ji, Joydeep, Anil, Shala ma'am, the Sodexo team, the AV and IT team, as well as all of the other individuals that have made it possible for us to both be here today as well as yesterday at the India Habitat Center, and all of the support staff at the Habitat Center yesterday who worked on very short notice to make a very, very exciting day possible. I'm also very grateful on behalf of CGLS to the entire team at CTIL, especially Professor James, Ridish and Pranav, who worked tirelessly with us over the last few months to make sure that we've managed to contact all our guests, get all of our presenters here in time, and even for those that haven't managed to make it, have them online and really engage with you in a very meaningful manner. At CGLS, as we celebrate our 15th year, this is a massive, massive moment for us because we've come together as a team after very long for an event of this scale. So it's also allowed us to understand how to work better together and really see the potential that we can carry forward as a team. So I want to acknowledge the entire team at CGLS: Firoza, Muskan, Anusha, Hari, Harshit, Natasha, Anmol, Surbhi, Brishti and Sanjana, and of course Professor Deepika Jain, without whose leadership we really wouldn't know where we would be. From JGU, it is only prudent that I acknowledge Professor Srijit and Professor Raj. They've been constant supports for us at the center for the last 15 years and have made us believe that any dream we carry forward will always, always find a platform. For the plenaries, for the 18 presenters, the 14 discussants, the chairs for all 6 panels, and our 2 wonderful distinguished speakers, Professor Thomas and Professor Bartels, we are so grateful for your time, and we really hope that this is one of the first opportunities that we have to engage with you in such an intimate setting. I also want to take this moment to acknowledge our student volunteers for today, Shreya, Tejas, and Shaurya, who've been running around all day to make sure you all have a great time at the JGU campus. I'm going to now hand it over to my colleague Pranav to complete the vote of thanks, and thank you again everyone for being with us.
Yeah, good evening everyone. Yeah. So before we conclude, I would like to thank the members of the organizing committee at and support staff at Center for Justice Law Society, JGU, and also Center for Trade and Investment Law. From CJLS, I would like to thank Anmol. It was like good time to work with you throughout like last 3 months, and most of our communication was with you from the CJLS. But I would also like to thank Disha, Firoza, Muskan, Surbhi, and if I have left any other name, like I would like to thank that person too. So it would not have been possible to organize this event smoothly without their constant effort and continuous support. So, and I also want to acknowledge efforts of our team at Center for Trade and Investment Law. Ridesh, who was like, consistent dedication has made this event possible. Without whom I would have been like throwing stones in the air, like. And I'd also like to thank Sunanda, Pushkar, Tiruthi, Aman for conceptualizing the plenary session one. Like we kind of what should be the scope of this session, and Mahima, Shiva, Jamshed for ensuring social media presence, and also Shana, Krishna, Bhavnesh, Sarthak for their efforts in organizing the event. So. And also Tarun. So I would also like to thank Professor Lauren Bartels and Professor Chandra Thomas for taking time out of their busy schedule to travel to India, for sharing their experience and insights, and also Neha, Sita ma'am from our finance team at CTI. And and also I like to give special thanks to Shri Anup Vadhavan sir for traveling to Sonipat on Friday to deliver special remarks. And My concluding vote of thanks will be for Professor C. Raj Kumar, who is an inspiring figure, and for his continued support to this symposium and many other events which JGU organizes. And I would like to thank Professor Deepika Jain for her guidance and assisting us in helping us in conceptualizing this symposium and framing the academic discourse for different sessions. I would like to thank Professor James Nedumpara for providing guidance and supporting us through the thick and thin in last few months and overcoming obstacles in making this event successful. And finally, I would also like to thank IIFT and WTO Chairs Program for their continuous support, and also to the panelists, chairs, discussions, and participants for their contribution to academic discourse during the symposium. And finally, the audience for their thought-provoking questions.
Thank you so much, both Disha and Pranav. With that, that is the end of our incredible today's symposium. Thank you, everybody who has joined us and who has participated. And this is just a small announcement for all our participants who have joined us for the symposium. We will be heading to Delhi Haat now. So if you will be joining us for the cultural trip and the dinner, we will soon be heading out of campus shortly.
One announcement, can we have a picture? Or everyone, I think, if you can come quickly.
And sorry, this is a more logistical announcement. If you are going to Delhi Hastas, please let us know as well so that we can just do count. Thank you.
You can just come for a quick picture. Thank you. I really enjoyed it. Thank you, sir.